you want to attach a face and something to this corporation, because otherwise everybody just loves to hate, the
Yeah.
corporation. And the law
I
says corporations are people too, right?
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. I am Megan Henry, and today I am joined by Sherry Bellitz and Rebecca Gregg, who've both been on before, and they are seasoned podcast guests. But today we're here to talk about reptile theory and nuclear verdicts and kind of the conjunction of the two of them, and both of them have a lot of experience with both, and they have a lot to say about it. So I'm just going to bring them in. Morning, ladies. Thanks for joining me today on The Defense Never Rests. Today we have Rebecca Gregg, who is a senior claims specialist at Napa River Insurance. Rebecca, how are you?
I'm good. How are you?
Good. And you've been a guest on the podcast before, not that long ago. But if anyone happened to miss that podcast, can you just give us like a short little rundown of what you do and what Napa River is all about?
Yeah, sure. So I'm a senior claim specialist at Napa River Insurance. We are a third party administrator, and all of our clients are large trucking companies that have pretty significant self-insured retentions. So these are my clients. I have about a dozen trucking companies that I work directly with to resolve their claims. And we handle everything, mostly injury and litigation type claims, but whatever they need me for, I'm their designated adjuster for it.
Awesome. And so also have Sherry Bellitz on. Sherry's been, I don't know how many times you've been on, Sherry.
Just twice.
Just twice?
Mm-hmm.
Well, welcome back for your third time's a charm.
The hat trick.
Yes. So Sherry is a litigation consultant and a CEO of Sherry Bellitz Communications, and she is an expert on what we're here to talk about today, which is nuclear verdicts and reptile theory. But Sherry, why don't you just give us a little synopsis of what you do and what your company does?
Sure. Sherry Bellitz Communications is a trial consulting company. And I sometimes think that's a little bit of a misnomer because it's really litigation consulting, kind of soup to nuts, even pre-claim we get involved. So I do mock trials, focus groups, all sorts of jury research. And recently we've expanded into the educational space, offering a course in Psychlawpedia. You could look it up on Thinkific, or I can drop a link. And we help teach lawyers how to apply psychology to their litigation practices to achieve favorable outcomes.
And you'll have to make sure I do not forget at the end of this podcast, remind me that make sure you let everyone know where to sign up and where to find all that information.
Sure.
So like I said, we're here to talk about nuclear verdicts and reptile theory. And it's probably something, we are familiar with, and I think a lot of people are familiar with. But, I would like to start with let's start with nuclear verdicts. And when you think about a nuclear verdict, what does that mean to you? Like, do you have a definition in your head, or is it a gut feeling? How do you define a nuclear verdict? And Rebecca, let's start with you.
Yeah, sure. So simply put, a nuclear verdict is an excessive jury award, usually $10 million or more, sometimes a lot more. Nuclear verdicts, in my opinion, are the result of personal injury attorneys successfully employing reptile theory in the courtroom. And it's a huge growing trend in a lot of industries. Mine especially is really impacted. I handle trucking claims, and the trucking industry has just been really impacted by this. And they're kind of new. I mean, 15 years ago, we really didn't have the kind of verdicts that we're seeing now. So it's really growing, and it's something that I think defense attorneys are trying to get caught up with as far as how they're going to combat this.
And Sherry, I'm going to go to you. Do you have any different thoughts or opinions on how you define a nuclear verdict in your head?
Sure. Well, I think Rebecca really hit the nail on the head. The technical definition is a verdict in excess of 10 million, but I think it's used really more informally to talk about verdicts that are disproportionate to a plaintiff's economic damages. And when we really are using the term is some of these big cases we see splashed across the news, like we've all seen the talc $4 billion verdict in St. Louis, and some of these Roundup pesticide verdicts around the country for hundreds of millions of dollars. So it's really these verdicts that shock the conscience. So yes, just adding to what Rebecca's saying, I think that's pretty spot on. And the trucking industry has certainly seen their share.
So, I mean, when we hear about, like, we see more of them, more and more of them. I mean, is it that, just the fact that they're happening, then it influences the next jury and it's kind of just a snowball effect? So what are your thoughts on that?
So I think it's really, and I've studied it from a psychological perspective. I'd love to hear what Rebecca says from an on the ground, actually handling this everyday perspective. But from a psychological perspective, and from the research studies, what we found is there's sort of a confluence of factors. You're really talking about the perfect storm of factors that are leading up to these nuclear verdicts. So about 10, 15 years ago, we did not have this phenomenon. It's been on the rise since about 2010. And as Rebecca mentioned, we can date that to the reptile theory, which I think is part of a larger problem for the defense bar, part of a larger phenomenon, which is plaintiffs' lawyers are getting savvy with social psychology, or they are getting savvy applying reptile, they are applying anchoring, they are applying all of these ancient psychological concepts to their litigation. Now, what do they have helping them kind of move things in that direction? They have third-party litigation funding, which I recently read an article that is going to be really big, predictions post-COVID. So you have third-party litigation fundings, it's funding jury research, it's funding experts, it's really funding litigations and letting them roll the dice and take risks that they weren't previously able to take. You also have an evolving jury, you have an evolving younger jury. I shouldn't say younger jury, but you have a jury that came of age during time of corporate distrust and less corporate dependence. So people will refer to it as your millennial jury, but really it spans some time, and you have less baby boomers, you have still Gen X like us, but you really have more and more millennials that came at they came to their formative years at a very different time than the generations before. And you're talking about a lot of corporate distrust. You have a cashless society, which is skewing the perception of a dollar. We are all able to easily pay for things with a click on Amazon. When I go like this, my kids say, "Are you ordering dinner?" Because I usually am ordering dinner on Seamless. A lot of these places, you're able to just kind of Apple Pay or use just different payment systems. And it really skews the concept of a dollar. And sort of along those lines, you're seeing outsized compensation for corporate executives, hedge fund managers, finance, Instagram influencers. So there is really a completely different way of looking at money. And of course, we all have information available to us all of the time. So this is in our faces, where maybe it wasn't in 1985 or in previous years. So that's kind of my piece on that piece of the nuclear verdict causes, the confluence of some of those factors.
And that's really interesting, because I've never given it that sort of thought in my head, that the connection to the dollar. I mean, I have added to the connection to the dollar, but not in the sense that you just explained it, that, like I know I never have a dollar, a physical dollar in my actual wallet. Like if a kid loses a tooth, I'm like, oh my God, what am I going to do? Because I don't have any cash. But, I and it makes so much sense that, when you see that, people can start making money on Instagram and be influencers, and there's just no concept of like there's less of a concept of going to work and grinding it out, so to speak, as it used to be, that I can see why, it can start to kind of snowball, and these nuclear verdicts have just become, it comes easier for someone to say, yep, 50 million. That makes sense. What are your thoughts, Rebecca?
Yeah, it really is kind of a self-perpetuating cycle with the way social inflation has just allowed this to kind of snowball and snowball. Um, I think over the past 7 years or so, that nuclear verdicts have jumped 300%. And as Sherry mentioned, litigation funding. I mean, there are people who are actually investing in these outcomes because, I received a demand recently, and I'll change some details to make it a little more hypothetical, but um, no visible damage to a vehicle. Don't really understand how anybody could have been injured from it. And just in no time at all, we've got $90,000 in medical specials. And, nobody would have dared to do that 15 years ago, but it's so common. And I see a lot of them. And I think a large part of it is plaintiff counsels have just really latched onto this strategy that works. They used to try to make a jury feel sympathy for their client and for the plaintiff. And now it's all about anger and it's all about fear. And, like reptile theory, it's tapping into that lizard brain that people have. So I don't know if you're familiar with the lizard brain, but should we give like a little rundown of kind of reptile theory? And
you stole my exact next question, because I was like, why don't we talk about what exactly reptile theory is before, because we're going to be interchanging it. So you get it, you go.
It's such a key to understanding how nuclear verdicts work. It's the the linchpin that holds it all together. So basically, to give kind of a rundown from my understanding of what reptile theory is, it's a litigation strategy that a lot of personal injury attorneys employ. And it's called reptile theory because it's crafted to activate the lizard brain of a jury. So your lizard brain, or your triune brain, it's located in your brainstem. Evolutionary speaking, it's the oldest part of your brain, and it's tied with all of those primal survival instincts, fear and aggression, the fight or flight method. And reptile theory is what every single nuclear verdict has in common. So these plaintiff attorneys try to activate this lizard brain, and they engage jurors on a primal level. They focus on safety and security issues, and they try to demonstrate how a defendant's actions put a plaintiff in danger. And they do it while stirring up all this anger and fear, and they suddenly make the jury feel like the actions of this defendant put everybody in danger, the whole community. And now it's up to the jury to be the voice for the whole community and to make sure that the defendant never hurts anybody like this again. And plaintiff attorneys are really, really good at it. They tap into that anger and they stir people up and they get results. And they're really good about crafting lines of questions that seem innocuous and seem innocent, and that anybody you might on face value agree with, like when they're disposing our corporate representative or something like that. And they start with something broad and they narrow and narrow and narrow the scope until they've pigeonholed the defendant into something where they can't back down from, and basically end up admitting that they've created some kind of safety or security issue. And it makes juries want to punish them.
Yeah. And the thing is, I think it, from a counsel perspective, I've seen it happen, and I just never, I guess never attached the definition to it, and you see the very skilled, and I have a few in my mind that are very skilled plaintiffs attorneys who do very, very well and are very good at what they do. And I'm thinking back to trials that I've been on or trials that I've monitored, and I'm remembering those lines of questioning that when they get to that last question, you're like, oh snap, they got him, and it
sounds so reasonable. Well, don't you think that we should all do our best to keep everybody safe? It's hard to disagree with that, but it starts out with something broad, and Sherry's so good at this, recognizing this. They do it it's so important to prepare for those lines of questioning, because they make them so they're yes, no questions, and you want to agree with it, and then suddenly you've boxed yourself into a place that you don't want to be in, and it's too late. We need to teach people how to recognize those reptile tactics, ideally to prevent them from even getting into the courtroom. But if they do, or if they're in depositions and everything, that we know how to spot them and we know how to react to them, so we don't get ourselves trapped.
Perfect segue, Rebecca. Let's talk about that. I mean, so Sherry, what's your take or your advice on how, we can help educate and counsel our clients and our insureds at how to, kind of prevent from getting in that hole and getting into that last question that you almost have to admit, defeat, so to speak.
Okay, so I'll come in as the fixer. Okay, so there are a couple of steps that we have to take. And actually, this is such good timing for this podcast because I just finished for Encyclopedia the reptile section. And Megan, I know you're a subscriber, so you can, I have sample questions, sample responses, everything. So you can study that and watch the videos and things, but I'll just give you the Cliff Notes version. Okay, so Rebecca, spot on. So the first thing that you want to do is you want to identify that you have the reptile on your hands, because if you get to the point where that corporate designee or those key defense witnesses are deposed and they're not prepared, it is too late. You're going to lose your settlement negotiation leverage. You are going to really have them locked in for trial. So this has to happen before those witnesses are deposed. But that's okay, because if you know what to look for, you're going to find it. You may find it pre-suit. You may find it in the pleadings. You will definitely find it in the written discovery. And that's where I want you to look for it. You're going to see certain phrases, not difficult to pick out. Safety rule, unneedlessly causes danger, endangers community. Danger to the community, needlessly endangers community, systemic problems, prior incidents. So actually in Encyclopedia, I have a whole list of the buzzwords. You're going to want to just check them off like a checklist and know that you have a reptile on your hands. Also, with certain plaintiffs' attorneys, certain types of cases, cases in the trucking industry, cases in big pharma, cases really implicating safety. I'm not going to say for a patent case you're really looking around for that reptile, but the reptile is finding its way into the coverage cases as well. And I did a segment about that. So early identification, looking for those buzzwords. Okay, you have them in your interrogatories and you're going to answer your ROGs accordingly. Now we get up to the oral discovery portion, the deposition. So those witnesses have to be prepared in a different way than you would for an ordinary deposition. When I prepare witnesses for an ordinary deposition, there's a series of steps. I like to give them a holistic version of the case and really an objective. I'm never feeding responses or anything like that, but I think if there's a holistic objective of the case, we're getting to the right place. However, in reptile, not only do they have to know the objective of the defense side of the case, they have to know what is up plaintiff's sleeve. They have to know what plaintiff is trying to do. And just like Rebecca says, starting from those broad questions, is safety the top priority at XYZ hotel? Is safety the number one priority at XYZ trucking company? And then suddenly narrowing the questions. So the witness actually has to be more proactive, usually. And I've been deposed. When I was in claims, I was deposed before, and it's very yes, no, I don't recall, as little information as possible, answer the question. However, in reptile, that witness has to be a little more proactive and not get themselves boxed in. And whether or not you believe the science, and there are people who have debunked, there are social psychologists that have debunked the reptile, you have to remember it for what it is. And I think Rebecca said it well, and I'll say it in a slightly different way. It is a strategic linguistic maneuver. And you know what? If you don't want to look at the science, don't look at the science, but look at it as like they are using the language to strategically box the witness into answers. And deposition, I'll tell you, is actually harder than trial. And I'll tell you why. But so at the deposition, you are going to want to, they're going to be asked these questions, trying to prioritize safety really, really broad. Then they're going to hit them with those narrow questions at the end, showing why they did not prioritize safety. So how do you respond? Now, remember, Safety, that's an illusory standard. That's not a legal standard. It's not a negligence standard. It's not an anything standard. It is a plaintiff's reptile standard. What's the real standard? The real standard is negligence. It's the reasonable person. We want to bring things back to reasonable. So if you talk to your witness about that as the overall objective, you're not going to have to feed them responses. You're not going to have to tell them what to say, because they're going to always go back to reasonable. So for example, if they're asked, is safety the number one priority at XYZ hotel? Well, safety, a good response would be, well, safety is one of many of our priorities. Safety is an important priority. We take reasonable safety measures. So always going back to that, but that witness is going to have to be prepared to take control. And if your witness takes control and does not flub those depositions, you are going to have leverage for when you hopefully settle the case. But if you do get to trial, trial is a lot easier, because depositions are done in a vacuum. It's just all cross-examination, and it is all eyes on the witness. Trial, defense attorney is going to get to present the story. They're going to get to present the reasonableness. They're going to voir dire on that. They're going to open on that. They are going to be able to do a great direct examination and really put that cross into context, which you don't get to do in a deposition. And this is why I say, get those witnesses prepared for the deps, number one, and everything else is going to flow so much easier. So that's my short answer.
Well, and really it's, taking control of the narrative back to the defense, and when the plaintiffs get control, they can just steer the ship, and you just have to claim it back. And claiming it back is preparation. And it's just like, Rebecca and I had talked about too, like when you have a catastrophic loss, getting to the scene immediately is super important, because you want to start controlling the narrative and start controlling how that litigation is going to shift. And it's no different for this depositions and preparing your clients. Now, I've been in these situations, and I think, any practicing attorney can say, you can prepare that witness till you're blue in the face and you think they got it, but then what happens when you're sitting there at the deposition and they just go rogue?
Break, lunch break.
Right. So I'm just gonna shift over to Rebecca for this. I mean, I'm sure you've been on the receiving end of a phone call from your attorney being like, look, we sat down with him or her for 8 hours. Yep. This is how the preparation went. We were good and we got in there, and this is what happened.
I try to make sure they're as prepared as possible. And I had that exact same scenario happen within the past year or two. So it doesn't always go as planned, but I try to really let my counsel and let my corporate representative know that it is so important that you take time to sit down. I want you to spend a full day, 2 days, get in person if you can, as much as you can during a pandemic. And I want you to put them through deposition boot camp. I want you to educate them on reptile tactics, the line of questions they can expect, and give them some examples of, in hypothetical situations, answers that work. Like, Sherry gave a really great one where they tried to pin you down with the safety issue and said, you say, well, of course, safety is one of the many things that's important to us, because they're just going to keep leading you and leading you and leading to you until they're like, well, why didn't you have any security on guard to protect against these roving gangs or whatever? And they've turned it into a liability thing where you've admitted fault and you didn't mean to, because you were agreeing with things that seemed perfectly reasonable. So, really spend time with the corporate representative, making sure that they understand those lines of questions and taking a deep breath and thinking about it before they have to answer. You don't have to answer right away. You can take a minute and you can put your thoughts together and you can reflect back on what you've learned. But really, they just need a crash course and they need deposition boot camp. And I need my attorneys to be kind of hard on them, because they're going to try to get them angry. So they say something that they shouldn't say. So go ahead, defense counsel, and make my corporate representative angry. Like, I know he's the president of a trucking company or something like that, but I think that was one that happened on one of mine where he seemed fine and he answered everything good, and he seemed to get it, and he was really calm, and I think everything was really polite. And then when it came down to it, he just got really mad and he just forgot and went off the cuff. So preparation is really key. So and this is really something more that I don't get as involved with. I try to be really proactive with my files once they're in litigation, but really there's a lot of stuff that I do as a claim adjuster before things get to this point, because I try to make sure that they don't get to a point where I'm looking at something going nuclear. I think that's the first thing a claims adjuster thinks when you learn about nuclear verdicts is, oh my God, how do I make sure this never happens to one of my files?
Yeah. And I will say, I think, the preparation part is so important, and really, pushing on those witnesses. Cause I've seen so many times that when the counsel is successful, just like Rebecca had said, is when they push their buttons just enough that they get mad.
Mhm.
And, and that's not a good look either, especially like a lot of the more sophisticated plaintiffs attorneys are now, putting everything on video. Now a lot of DEPs are on video just by default, but even before the pandemic, they would record it. So they would have those angry statements on video, and they would have that witness looking just pissed off, and they can use that.
And your corporate representative isn't just there to navigate all of these difficult reptile questions. We're also trying to humanize the corporation that they're representing, and to make them relatable and likable to a jury. And because people love to hate corporations and people love to hate semi trucks, really. So, my clients, we have a lot working against us. So we want to make sure that our corporate representative is reasonable and likable and personable and seems like, somebody that that you like and would want to spend time with. We want to show that they're family people, they're doing important things in the community, that they're not just some nameless, faceless corporation. If there's a trial, I want them there every single day, sitting where the jury and everyone can see them, because that shows, hey, we care about this plaintiff, we care about what happens here. And it's not even just about money or anything. We care about what happened, and we want to make sure that we're demonstrating that, and we're here for this plaintiff and to see what happens with everything. So you want to attach a face and something to this corporation, because otherwise everybody just loves to hate the corporation. And the law says corporations are people too, right? So let's get a person there with a face on it and make sure they do a good job representing them.
I agree with that so much, because I think it just makes such a huge difference to have them there. Like, I've had trials that they're like, well, I have this one thing this day. I'm like, sorry, this is more important right now. Like, I need you sitting right here next to me and being attentive and being there every single day. So I'm going to throw this to you, Sherry. So say you've made it through the deposition stage, pretty much unscathed. Things look good. You head to trial, and then suddenly things take a turn. What happens then? Like, how do you navigate it? Say you have this perfect deposition testimony, but suddenly at trial, they're able to get to your witness and they contradict themselves in what they said at deposition.
Well, that's an interesting question, because I think if you have everything set up, if you have done everything that you possibly can do from that deposition all the way through trial. Well, first of all, I think if that deposition goes well, let's hope that you have some serious leverage at the negotiating table. That's kind of number one, right? Because we want to get the case settled. And then back to the point about humanizing the corporate defendant. So Megan, you made the point, look, Rebecca said, be here every day, you need to have a face. And Megan, you made the point that, maybe they have a meeting one day, they have something one day. This is actually a very good tactic when you are about to possibly settle the case. And let's say the company really wants to try it. You kind of tell them what their commitment is. Say, look, we are humanizing you, and this is going to be a 2.5 to 3 week trial. You are going to need to be there this many days at least. Something like that can be a big deterrent for them actually going to trial and kind of realizing the cost benefit of that, and can get you in a better place as far as your company and mediation. But that being said, if things fall apart, if you are not able to settle the case, you have a good deposition, you get to trial, you have to set yourself up as best as possible to deal with the setback. And like I said, there are things that are somewhat easier at trial. You have more control than you do when you're just having your witness cross-examined. You're going to get to set a theme, have your narrative, take control of your narrative, deselect. I never say select your jury, deselect your jury, ask those careful strategic questions, get those biased jurors to talk and get them off your jury before you even get going. That's kind of number one. But you're going to get to set the tone, set the narrative. Direct examination, really, really important for those corporate witnesses, especially if you know they got reptiled at the deposition or attempted reptiled at the deposition. You are going to want to lay a foundation to really have them succeed on their cross. What happens if they fall apart on their cross? I will tell you, if they were deposed and did a good job, it's going to be really, really hard, unless it was maybe a really super terrible day. And, you know, maybe you had someone who wasn't that expert deposing them, and now you have all of a sudden Mark Lanier comes in to cross-examine them just out of parachutes in out of nowhere and decides to do this scathing cross-examination. You will have a chance to rehabilitate them. You will also have a chance to reverse that reptile if there are any allegations of contributory or comparative negligence, and show how that plaintiff has a safety standard as well and maybe did not follow that safety standard. So there are a lot of different techniques you can use. But I guess my main point, and look, we've all had or heard of witnesses that fall apart, but if you have a strong dep that they are locked into, you're going to be able to rehabilitate them after cross. But I really think the case, I always say the work is done in the office. The trials are won in the office. And if everything is set up, and I'm not saying everything is a winner, and you know what, maybe sometimes a $500,000 verdict is a winner. So in a subjective context, you are going to really just have to have that deposition go so well that everything sort of follows from there. So I know that's not completely answering your question. What if your witness has like a horrible day and, you know, shows up like, you know, inebriated, and Mark Lanier comes in and does like the best cross that he's ever done? Yes, that's tough. But what I'm saying is, if you take the pre-steps, that shouldn't happen. And if you have good deposition testimony that they're locked into, that shouldn't happen. But again, you can always reverse that reptile. You can always play their game against them, and there are options. So also a during trial settlement could be an option if Mark parachutes in. But really, if your case, what I'm just trying to say facetiously is, if your case is set up from the beginning, you are going to be okay.
And I wanted to add, even if they do kind of screw it up a bit, it's still salvageable. I mean, remember that the plaintiff attorney is trying to make the jury angry at us and angry at our corporate defendant and our company and our driver. And nothing takes the wind out of their sails more than owning up to whatever we need to own up to, for accepting responsibility for our role in the accident. Maybe we're not accepting liability. Maybe there's some contributory negligence that Sherry says, you know, we could say that we're responsible. We might ask the jury to determine who else is responsible in it. But it's really hard for them to get the jury angry at us when we're being completely reasonable and saying, you're absolutely right. We accept responsibility for the role that we played in the accident. And, maybe you're going for a defense verdict, or maybe that you're 100% at fault and you're trying to settle it, or maybe it's somewhere in between and there's some contribution. But if you go up there and you're very reasonable and you own up to it, because juries will see right through it. If you're trying to point a finger at some poor kid who had to have a surgery because of an accident, because your driver caused something, they're not going to like you very much. But if you own it when you need to own it, it just sucks the wind right out of their sails and makes it really hard for them to stir up all that emotion that they're trying to stir up in the jury. So that's always something that I try to look for, even if I'm not accepting liability for a claim. There may be some things that we need to accept responsibility for, and I always look for opportunities for settlement discussions. Some claims we fight, but I honestly don't have a whole lot of claims go to trial, because we're always looking for opportunities, or at least I am, to get the most economical solution for my insureds. My insureds have pretty huge self-insured retentions, and a lot of them pay 100% of their expenses. So, I want to try to be mindful of that and do the best possible thing with their money. And so sometimes we have a talk about if it's something that we need to have a settlement talks, or even if suit is filed, maybe we want to try a mediation or some kind of pre-suit settlement conference. But even if it's going all the way to trial, when we get there, we definitely don't want to be the people who are just like, we didn't do anything wrong, and pointing fingers at the person that is perceived to be the victim here.
And I have to agree with that. I think the sentiment of I'm sorry, I think goes very far. Even if I'm sorry, I may not have been negligent, but I am sorry.
Yes.
And I think, in the trial atmosphere, or even at a mediation, I think that just carries so much further than trying just put up your hands and start the boxing match. And I think even if a jury sees that someone has, feels sorrow for someone's, injuries and damages, may not be owning up to responsibility for them, but, has some sentiment of being sorry for it. I think that says, that humanizes a company, that humanizes a witness, and can also, I think, rip apart plaintiffs, not case, but tactics.
Mm-hmm.
And I always, a lot of cases when they go to mediation, I often counsel my clients to say, I want you to be, even though you don't have to be here, I want you to be here so you can, look at the plaintiffs in their face and just express it. You're sorry for what they're going through and you feel for them. And I find that does it, it helps, I think.
Please sound like you mean it.
Well,
Please
yes.
sound like you mean it.
Don't
Because
say
if the jury doesn't think you mean it, it's doing more harm than good.
Yeah, don't say sorry like my 8-year-old. Sorry, but I didn't do
Sorry.
anything.
That's exactly how my 8-year-old says.
Sorry, not sorry.
It's like, sorry for nothing. And on that note, I lost track of what I was thinking about. So back to talking about resolution, though, and trials. I mean, do you find the fear or not? I don't want fear is not the right word, but the anticipation of what a reptile theory can do to a case, and unpredictability of juries, as well as potential for nuclear verdicts, does that tend to steer you away from trials, for these higher exposure cases, to, again, and I see it with my own clients, to limit, bad press in their name, limit, like for Rebecca's clients, money directly out of their pocket, or just even insurance companies. I mean, you don't want to have that big loss on their books. So, how do these things help steer you towards resolution, even when you might have clients who don't want to resolve? And I'll kick it to you, Rebecca, first, because you're dealing with your clients and insureds directly, probably a lot on this issue.
Yeah, absolutely. I mean, it's something that I have to be constantly aware of. If you're a claims adjuster in this current climate, you have to understand, how nuclear verdicts are affecting your particular industry, and what reptile theory is, and how to combat it. So, because like I said, you don't want to get one. And I think that there are a lot of things that a claim adjuster can do before a file gets to trial, before it gets to an expert like Sherry, that can be a great help or a great hindrance to our chance of success. So once you understand how your particular industry is affected, like for me, trucking, there have been hundreds of cases with awards over $1 million for trucking companies in the past 5 years. Just recently, there was a verdict as high as, I think, $400 million on a Florida loss against a trucking company. So these big verdicts are happening more and more often for more and more money than ever before. It's hitting my industry really hard. A lot of trucking companies are going out of business. A lot of drivers are losing their jobs. So I have to take that into consideration, especially for my clients who are footing the bill on expenses, who have large self-insured retention. So with that in mind, I have to really adopt a claim handling philosophy that gives considerations to all these particular challenges that they're going to face, and I have to integrate them into my decision making. So that means that I try to focus on outcomes. I don't put off making a decision. I prioritize making contact with parties as soon as possible. We've done a segment on catastrophic claims, and if it's a serious injury, we talked about the things that we need to do as far as getting your boots on the ground representative, getting defense counsel out there, making sure you're doing everything that you can to preserve evidence, because I have to be conscious of the fact that, especially for trucking claims, it's not always going to be as clear cut or as simple as I want it to be, or my insured wants it to be. And it doesn't always seem like it's an obvious thing. Sometimes you could think of some horrible scenarios which might lead to a nuclear verdict, but then there are some that are just really, you just kind of gradually build and build and build and build. And suddenly they're asking for $60 million for somebody who had a 2-level spinal fusion or something like that. And that's just kind of what the current climate is. So I have to make decisions based on finances and instead of feelings. And like I said before, sometimes even if I don't think we should accept liability, we might have to take a hard look at the claim and determine if it's something that we need to accept responsibility for, and if it's more economical for us to settle a claim rather than deny it and let it go into litigation. So those are conversations that I sometimes have to have with my clients about what they want to do. Sometimes the best claim is a settled claim, and that doesn't apply to all of them. A lot of claims will go into litigation. And, if that happens, then I need to just really keep paying attention to the file, because I think some adjusters, once it's in their hands of their defense attorney, don't pay attention as much. But this is really an opportunity for you to manage this litigation plan in various stages. Look for opportunities for pre-trial settlements. Look at the deposition questions that the other party's asking and see if you can spot some of these reptile tactics, and make sure that you're getting your corporate representative the preparation that he need. Have conversations with your counsel about if all of these questions that they're going to be asking is really something that's going to be admissible. Or there's some what's it called? Motions in limine.
Limine. Yeah, limine.
I did it close enough that you can file. To keep some of these reptile tactics from even being heard by a jury. And, really just keep an eye on your file and look for those opportunities to get it done as economically as possible, because I'm really trying to avoid getting a nuclear verdict. I don't want that on my record. So yeah, it's always in the back of my mind. It's always something that I think of. And it kind of kills me. I hate it. There's so many that I have right now where my heart just wants me to fight it. I know it's bogus. I know it's so bogus, and I want to fight it. And this is a career plaintiff. I pulled up his ISO record. He's been in 7 or 8 accidents, represented by the same attorney. I know it's bogus. And they sent me $100,000 in meds that he got in a couple of months. And gosh, I want to fight it, but maybe I can get it settled for cost of defense. And I don't know what to do. What are we supposed to do with these situations? Because I feel like it's just perpetuating this cycle, but I have to protect my insured, because one bad verdict could bankrupt their entire company.
Right.
It's so hard.
And as as counsel, I feel that pain equally as you do, because you want to defend it too. You see the legal arguments, you see your defenses, and yeah, and I mean, and there's sometimes you got to put up that fight, and there's
Mhm.
other times you just honestly, you have to always have the conversation and have the options and discuss them with your clients and figure out what is in the best interest of all.
Mhm.
And so I'm gonna push to Sherry right now, though, because I kind of think, Sherry, sometimes that's when you come in, and if you're looking at a case, right, clients come to you and they're like, look, we might be headed to trial. We need you to look at our strengths and our weaknesses and let us know what you're looking at. And I think, at least, correct me if I'm wrong, but I think your perspective on the case can really push things or drive things towards settlement. You're like, look, you can spot the issue and say, look, you got an issue right here, and it might head you to this left direction, and it might blow up in your face. Am I wrong?
I think I think that's exactly right. And kind of piggybacking on what Rebecca said, like sometimes you think you have something, it's so bogus, your emotions take over, you want to fight it. Like you said, you've seen the career plaintiff, but at that point, it might be good for you, good for the company, good for your insured. If you put that, and this is just information, not infomercial, but if you put that, so let me explain the difference. Focus groups are done early, usually pre-discovery. Mock trials are done later as we're getting to the tail end of discovery. I like to usually use deposition clips in those, which is very helpful. And then there can also be a focus group added to a mock, which is just what we do. But so let's just say focus or mock, let's use it interchangeably. So you have this case, it's bogus, but they're asking for $60 million for nothing, and it's a career plaintiff, and it is boiling your blood. Take a step back, put it before a focus or put it before a mock if you've gone through discovery, and then see what your mock jurors say, because what you may think is bogus, maybe there is something in there, they're going to hit upon it. And I've seen mock juries hit upon themes that we think are absolutely insignificant, but they become linchpins, they become anchors. Or maybe there's themes we're really concerned about and they're just kind of like, okay, that's a non-issue. So you put that before a focus or before a mock. Your mock or your focus group is going to yield one of two things. It's either going to give you leverage, like you said, you were ragey, you want to go to trial on something, it's BS, and your focus group or your mock tells you just that. And then you have that report, you have that quantitative data, you have that qualitative analysis, and you have the backup, which you're going to need at your company when you run it up the chain. Look, the mock jurors said it was bogus, and this is why, and this is the data. Or it is going to yield for you some knowledge. It might not yield you leverage. It might not be what you want to know. It might be what you thought was bogus, and they're asking for 60 million, and it's that career plaintiff. You know what? Those mock jurors may say, yeah, this is 50 million, 40 million. And even if they don't give you a number, because sometimes we will just mock for liability, they may say 100% liable. They may pick something out that you never thought. So even if your mock does not yield leverage, your mock might yield knowledge. And then you have to kind of go back and reconstruct your analysis, your authority request, your reserving, and really think about where you want to go with this. So it is very informative when your emotions start to kind of take over and want to go a certain way with it. This will give you that objective analysis. And as I like to say, look, mock is the gold standard, but we know it's not always possible. I used to work at an insurance company. Sometimes it wasn't in the budget. Sometimes the demand just wasn't high enough to merit it. Sometimes there wasn't time. Sometimes there was a protective order if there was a companion criminal case or something, for example. So if you cannot do that, there are other things that you can do, and something is better than nothing to get an objective analysis of your case. So I think it's really important. If you think you have something, bad on your hands, or if you think you have something totally defensible on your hands, but some outrageous demand, go put it before an objective panel or two panels or four panels of people in that demographic or in that representative jurisdiction, and you will be able to get a more informed, objective opinion.
I agree with that so well. Sometimes, I will toss, hypotheticals to my husband, who's not an attorney, has nothing so far away from legal, and hearing how he perceives things is totally different from if I were to talk to, one of my colleagues, because we're all in that mindset, like, oh, okay, they broke an arm, this is we have our tickers and we decide, what's worth what. And you toss it to someone who doesn't do that normally, and and it can go either way. Like, sometimes he'll be like, why would you pay for that at all, or he'll be like, oh, I think that's like $1 million. I'm like, are you crazy? So I think getting that objective view really helps, because let's face it, we all get stuck in the weeds and we all think that our cases are worth X, because we're so into it, or they're worth zero, or whatever it may be, but we're so into it that taking that step back and taking the step back out of someone who isn't so far into it is really, a valuable experience.
That's something that I ask all of my clients to do, because a lot of them are just like, well, this is ridiculous. We're not at fault for this, but really have to think like a plaintiff attorney on this and take a good, hard, honest look at all the facts of your case, and, make sure that there isn't something in there that can be used against you, because you might not be too concerned about this because, maybe it said you were going 64 miles an hour in a 60-mile-per-hour zone, but you don't really think that played a role in the accident, or later you had a failed DOT inspection, or there might be some little snippet in your company guidebook that doesn't quite align with all of your safety practices and things. But you have to look for all of those things that can be perceived weaknesses that they can use against you, because it might not seem like a big deal to you, but I mean, that could be huge with how they turn the jury and how they affect the perception of your liability in it. So, just be mindful of all of those things and take a good, hard, honest look. And, those are sometimes things that we start to understand those, and then think if, maybe this is something that we need to settle on, something like this, because this is something that could blow up for us. So it's not always as clear cut as you want. And there's so many nuclear verdicts recently that have just been insane. Like, you just wouldn't think that you're at fault at all. You wouldn't think that a tractor trailer driving in the right lane down a divided highway, and then another vehicle loses control and comes across and hits it head on, you wouldn't think the tractor trailer would be at fault, but that's a $90 million nuclear verdict against that trucking company. And so you just have to be honest and look at all of these things, because it's never as clear cut as you think it's going to be.
No. So my last question though is, so say, and Rebecca, you're probably the best person to answer this, but say now you're on the receiving end of that phone call from your attorney, or you're at trial, whatever it may be, and you get word that you just got hit with that $90 million. What on earth do you do at that point? Besides like want to poop your pants?
Cry? Drink? I don't know. Okay. Now, full disclosure, I handle some claims in the excess level, but if a claim gets up to that kind of money, I'm usually not the person who's handling it. This is usually our excess carrier or something. So fortunately, I'm not probably going to be the one who's going to have to make a game plan to what to do with that. But there have been a lot of huge nuclear verdicts in recent years that have been reduced in appeals. But I mean, still, if you cut 90 million down to 37 million, it's still an insane amount of money. I don't think people understand how much money is, like how much money is in between 1 million and 5 million, or 25 million and 50 million. It's insane. And so, I mean, if we've gotten to a point where there's a kind of verdict like that, we really messed up in the courtroom. I think a lot of plaintiff attorneys aren't afraid to throw out a number, and they throw out a number early and often. I mean, they'll do it in voir dire, and they'll be like, well, how would you feel? Do you think you would have any problem if the evidence suggested that this is a $200 million claim, would you have any problem granting that to them? And they try to get away with it by saying, well, I need to make sure there's no bias or something like that. But they'll say the number over and over again, and suddenly the jury thinks it's a $200 million case when it's not. And defense attorneys need to get in there too. And well, what if the evidence suggests it's only a $500,000 case or something like that? Would you have any issue doing that? And I mean, we need to throw out an anchoring number too, because that's what they're doing. They're going to say their number. They're going to say $200 million over and over and over in the course of the trial, and convince the jury that that's a reasonable value for it. So we need to provide some kind of, take a thumb off a scale and provide some kind of balance for that to make the jury understand. Because I think in some of these, the jury might not even be all the way convinced, and they're like, well, I feel like we have to find that he's guilty or put some negligence on this guy, but I really like the defense attorney and I think he made really good points. And so let's say 100 million, instead of 200 million, like that's really a lot better, right? It's still huge. It's still a tremendous amount of money. So we really need to very early let them know that's not the value of the case, and talk about how, who our plaintiff is and what they enjoy to do and how $500,000 would tremendously affect their quality of life or something like that, and make the jury think about it in those kind of terms, how it's specifically going to affect this particular plaintiff. Because gosh, if we get to that point, we didn't set it up right with our jury and make them see, because they thought it was a claim, because I don't know that people don't know how much $200 million is. It just seems like a lot of money. And if somehow a plaintiff attorney has worked in some golden rule that they shouldn't have, like, well, how would you feel if you got $200 million? Well, that'd be pretty good,
Yeah. And Sherry, do you agree that placing those numbers in the minds of the jury really can push them?
Yeah, I think there are a couple of really good points there that Rebecca made, and we kind of circle back to the skewed concept of the dollar, like how much is something worth? So defense attorneys really have to do a great job at arguing damages. It's something that plaintiffs' attorneys have been doing a long time. And as Rebecca said, they are anchoring and they are priming. That is what they're doing in voir dire. And plaintiffs set that first anchor. And in psychology, we know that that first anchor, unless it's refuted effectively, is going to be the filter through everything that you hear. So plaintiffs, and I read a lot of plaintiffs' publications, and there's a plaintiff's lawyer that I admire a lot, and he was talking about arguing damages. And he was talking about how, just as Rebecca said, he's going to talk about it in voir dire to detect bias, but really what he's doing is anchoring and priming and talking about that number and comfortable with that number and making the jurors comfortable with that number. What defense has to do, and defense is so used to thinking it's a zero-sum game, and they want a defense verdict and they deserve a defense verdict. And how is that going to get them a defense verdict if they talk about numbers also? But studies show that it will. And defense counsel has to break down damages and talk about what's reasonable and talk about medical and talk about non-economic and really break down numbers, maybe sometimes even show it on graphics and show it on visuals or demonstratives and break down those numbers and show why this is not $100 million that plaintiff's attorney was priming and anchoring, but showing that maybe this really looks a lot more like $200,000. And you know what? At the end of the day, maybe there is zero liability, but if you are going to give a number, and this has also been shown to diffuse anger, give a number, argue damages, explain it, because otherwise that skewed concept of the dollar, that anchoring and that priming that goes on in the beginning is going to be what carries the day. So I think Rebecca's completely on target with all of those things that she's saying.
I love it. I think if I could sum up what I got out of today is preparation don't be afraid of the numbers, and kind of you just have to battle back. Defense has to take a stronger position and battle back against council. Not that we haven't, but we just need to take almost a different approach. They've changed their approach, and we need to kind of adjust and counterbalance our approach too. Like the same tactics that have worked for years aren't going to work so much anymore. You have to adjust. So thank you guys so much for coming on again today. I love having both of you on the show. I hope that, this is the beginning of a long tenured friend guest friendship on this Defense Never Rests. Now, I promised both of you. So Rebecca, can you let everyone know where they can find you? I know you're just during the pandemic, you amped up your LinkedIn game and you're being much more active on there. So let everyone where they can find you on LinkedIn and how they can interact with you.
Oh, sure. Yeah, I'm on LinkedIn. My name's Rebecca Gregg, Gregg. So go ahead and add me. I'm always looking to connect with other claims professionals, trucking companies, defense attorneys, anybody in the transportation industry, and try to do my part to educate people about what's going on in our industry.
Yeah, and Rebecca's great at interacting with posts and comments and everything. So, and Sherry, I know you have a lot going on right now. You got a new course coming out, so let everyone know where they can find you, where they can sign up for your course, where they can find your company, everything.
Okay, absolutely. So I like to say I have my LinkedIn screen open probably like 20 some hours a day. People have even asked how I've get work done because I always have LinkedIn open. So you can look for me on LinkedIn. I will always DM you back, Shari, Shari, Belitz, B as in boy, ELITZ. You can take a look at my website, Shari@sharibelitz.com. I'm sorry, that's my email, but you can email me too. And my website is www.sharibelitz.com. You'd think I'd know the distinction by now. And I have a course. It actually started today. Megan, I know that you're a subscriber. There's some people from your firm that are subscribers, and that is in psych law. Get it? Psych law. I apply psych to the law, pedia, and that's on Thinkific. So that's in psychlawpedia.thinkific.com, and you can check that out, but that's all over LinkedIn as well. So always directing everyone back to LinkedIn, and that's where you can find me. I love interacting, and actually Rebecca and I met on LinkedIn, so
us as well. So
and another place to find you too. I'm going to brag on you.
Ooh,
congratulations on your book network.
Thank you.
Thank
Awesome.
you.
I enjoyed both of your chapters very much, and a lot of other people. I think I follow every single one of these ladies on
Good.
LinkedIn.
Thank
So
you.
I had it ready.
So
I've read
nice.
it after you sent it to me, Sherry. So thank you so much.
Oh, good. I'm glad.
You guys have just done such a great job building a community in 2020 and bringing all these women together and being super supportive. And I super appreciate it. And I'm glad to be, in my own small way, connected with all of you guys.
Well, thank you. Yeah. And yeah, for anyone listening, please pick up a copy of Networked. It's available on Amazon.
That's great. And we've built a great community on LinkedIn.
Yeah.
So come join us. We have fun. It could be Saturday night. We're in our pajamas, sipping a cocktail, having a good conversation, having some ice cream maybe. So definitely join us.
But thanks so much, ladies. This was great.
It was so fun.